A very good day to everyone. Thank you for taking time out of your busy schedules to join in our Competition Law podcast.
We were exploring ways to create greater awareness on your day-to-day issues and reminding that competition law is something you needed to look at. And podcasts seemed a good way. We saw this as a way to connect with all of you as well. The podcast will be done by my colleagues and I across the ASEAN countries that we work in, and we'll discuss various issues. We hope that these bite-sized recordings will be helpful to you and something that you can listen to on the go whenever convenient. Please do feel free to reach out to any one of us by phone, by email, by instant messaging if you'd like to discuss any of the issues raised further. Now, to start, we discuss a question that we commonly receive from clients, which is, does your distribution agreement comply with competition laws in ASEAN? You know, there's a common misconception that competition law is only concerned about agreements between competitors. It cannot be far further wrong from that. The reality is competition law also impacts agreements between suppliers and distributors and essentially the supply chain, across the supply chain. Hence, even with distribution agreements, which is not a horizontal agreement, there could be vertical agreements. Now, to start off, we have Jane, my colleague from Malaysia, who will give us a quick introduction as to how distribution agreements are assessed under competition laws.
Thank you, Carla. Yes, apart from agreements between competitors, competition law governs also agreements between enterprises operating at different levels of the production or distribution chain. And these are what we call vertical agreements. There are various forms of vertical agreements, and distribution agreements being one of them. Distribution agreements, which simply determine the price and quantity for a specific sale and purchase transaction between the sellers and the distributors, do not normally restrict competition. But there will be competition concerns when the agreement contains restraints on the distributor. So does that mean distribution agreements are anti-competitive whenever they contain restraints then? The answer is no. Distribution agreements are not automatically unlawful just because they contain vertical restraints. In Malaysia, an agreement of such will only raise competition concerns if it has the object or effect of significantly preventing, restricting, or distorting competition in the relevant market. And what does significant mean then? The Malaysia Competition Commission has in this respect provided that there is a safe harbor of 25% market share for vertical agreements in Malaysia, which means only if at least one party to the distribution agreement has a market share of 25% or more in its relevant market, that the distribution agreement would raise competition law concerns. But then, even if any one party has a market share exceeding the safe harbor threshold, this is not an automatic infringement. The Commission would carry out an effect-based analysis taking into account various factors before deciding whether the distribution agreement is anti-competitive or not. It is also important to note that vertical restraints such as exclusivity, which is very commonly found in distribution agreements, can also raise concerns under the Prohibition Against Abuse of Dominance prohibition, and the indicative market share threshold in Malaysia for this is 60%. So as you can tell by now, with the safe harbor and also the need to carry out complex economic assessments for vertical agreements, proving infringement for vertical agreements like a distribution agreement is not as easy and is actually harder as compared to establishing cartel activities. Nevertheless, a considerable amount of the competition enforcement activities carried out by the competition authorities in the region have concerned distribution practices. And we also observe a trend in Malaysia that MyCC's enforcement activities in the area of vertical agreements are becoming more active these days. Hence, we would definitely see an uptick in cases involving vertical restraints in the not too distant future.
Jane, that was very insightful. The explanations that you have provided in terms of how distribution agreements are to be assessed under competition law whilst looking at it from a Malaysian perspective, I believe applies across many other countries too. And yet, there might be a slight exception when we are looking at perhaps Singapore and Brunei even. Now, talking about Singapore and the possible exceptions, Tanya, my colleague from Singapore, jumps in now.
Thanks, Carla. Yes, let me highlight a relatively unusual provision that we have here in Singapore. So under the Singapore Competition Act, vertical agreements are excluded in the first instance from the prohibition against anti-competitive agreements. However, vertical agreements are not excluded from the prohibition against abuse of dominance. What this means is that vertical agreements will generally not raise issues under Singapore competition law, except where one of the entities to the agreement may be considered as a dominant entity or having substantial market power. On this, the indicative threshold for dominance in Singapore is a market share of 60%. But note that the 60% market share threshold is only indicative, and dominance can actually be established at a lower market share, depending on other factors such as the level of barriers to entry in the market, the availability of countervailing buyer power from the customers, etc. Therefore, notwithstanding the vertical agreements exclusion in Singapore, we would generally still advise clients to exercise caution in their vertical agreements, where either they or the counterparty may be considered to have market power, or if their vertical agreement can be considered to have the effect of a horizontal agreement.
Tanya, thank you for that. Now, one thing that comes up immediately is if you have an exception in Singapore or in some other countries, but not in other countries, how do you then structure your vertical agreements, your distribution agreements in particular? Makes it a little complex, right? And this is something that we may need to discuss further as you structure your agreement. But for today, what we're going to also do is pick up on some of the critical clauses that typically appear in distribution agreements and have a quick discussion in and around those. Some of these clauses include exclusivities, resale price maintenance, individualized rebates, just as quick illustrations. Now, to start off with exclusivity, my partner, Vovo, from our Indonesian office, explains how this operates.
Thank you, Kala. That's a good question. Well, in general, when we prepare distribution agreement, we should be cautious on the limitation or restriction we set for the parties to the transaction, including on the methods we want to use in distributing the product, especially if we want to use exclusivity clauses. This clause can take the form of appointment of exclusive supplier or seller, assignment of exclusive territory, or customers of certain class or group, as well as non-compete obligation. Generally speaking, exclusive means there is only one supplier or distributor for a product in certain market. The exclusivity clauses may be beneficial not only to the parties, because they can promote efficiency or prevent free rider, but also to customers because they can receive better services. That should be okay, right? So why is it problematic or anti-competitive? Well, because it may foreclose competitors from accessing the market and thus foreclose or limit consumers from acquiring competing and possibly better products or services. When I talk about competitors, they can be businesses selling the product with the same brand, so there will be reduction in intra-brand competition, or businesses selling competing products or brands, which can result in lessening of inter-brand competition. This foreclosure effect will be significant if the parties applying this clause has substantial market power or dominant position. So, if we want to adopt exclusivity clauses, we should take into account the parties' position in the market, whether or not they have substantial market power or dominant position. Of course, we have to define relevant market first so as to determine or estimate their position in the market. When you or the client wants to include an exclusive clause in the agreement, you have to be mindful of the justification or reason of why you want to have it in the agreement. Is it to enhance efficiency, promote better services, or is it to foreclose competitors? Foreclosing competitors will of course raise competition concern. Duration of the exclusivity is also important. When the exclusive dealing lasts for 10 years or more, it may have substantial effect to the competition than if it lasts for just few months or years. Exclusivity clause is an example of problematic clause under vertical restraint that do not relate to price. There are other clauses that relate to price that may also be problematic from competition law perspective that we could encounter when drafting distribution agreement, such as resale price maintenance and rebates.
Thank you very much, Vovo. Whilst I thought exclusivities could be very complex, you have structured it in such a way that it actually really doesn't sound so difficult. Caution is necessary, but it is manageable. What about resale price maintenance, as you rightly pointed out, Vovo? Jane, my Malaysian colleague, hops on again to talk about RPMs.
Thank you, Carla. Yes, as Part Vovo pointed out, resale price maintenance clauses can be problematic from competition law perspective, and it is crucial that you take note of such clauses when drafting your distribution agreements. Typically, resale price maintenance occurs when a manufacturer or supplier establishes a fixed or minimum resale price, which a distributor or retailer must observe when reselling the contract goods or services. It can be achieved directly or indirectly, and it is typically viewed as a serious infringement of competition law in most competition law regimes, leading to a restriction of competition in the downstream market. As regards maximum resale price, on the face of it, maximum resale price is good for customer, as there's a ceiling price which the distributor can on-sell to the customer. Ultimately, the objective of competition law is to protect consumers, right? However, maximum resale price will generally be permitted only if it does not serve as a focal point for downstream collusion. Same goes for recommended resale price. It is generally permitted provided it does not amount to a de facto minimum or fixed resale price. For example, if you recommend resale prices to your distributor, but the distributor is prohibited from reselling the product below the recommended resale price, or if the distributor is penalized for selling below your recommended resale price, then obviously the recommendation is not a genuine recommendation. So by merely labeling a resale price as a recommended price does not mean it will definitely not raise competition concerns. Again, as mentioned earlier, a vertical restraint like a resale price maintenance clause is not automatically anti-competitive. The market shares of the respective parties in a vertical relationship will have to be looked at, and the Commission will need to carry out detailed competition analysis to assess whether such clauses indeed result in significant anti-competitive effect in the relevant market.
Many thanks, Jane. Friends, resale price maintenance, recommended resale prices. This is an issue that competition commissions across the world pick up on fairly frequently. Indeed, if you tie this into e-commerce concerns, the complexities are heightened. So do pay heed to your RPM clauses. Ideally, never have fixed. And if you must have some kind of recommended prices, be cautious as to how you craft that. Now, moving on into something slightly different, talking about discount schemes, rebate schemes. This sounds easy enough. Now, if I have a distribution agreement put in place, it's only common that I would want to offer discounts or rebates. But a structure that I put together in Singapore, can that be applied equally in Thailand and the rest of the countries that we're talking about? Not so straightforward. What you're going to hear next is Tanya coming on board to very quickly talk about discount schemes as we have them in Singapore. And then Supawat, my colleague from Thailand, jumping in to explain the nuances that exist in Thailand, which makes it somewhat different as well. Tanya, Supawat, over to you.
Thanks, Carla. Yes, discount schemes are commonly employed by businesses as a form of price competition and are generally good for competition. As consumers, we all love discounts and we can attest to this. However, certain discounts or rebates, especially when offered by a dominant undertaking, can have the effect of harming competition. For example, discount schemes can be structured to achieve the effect of exclusivity which Park Vovo spoke about earlier. Discounts can also be anti-competitive if it leads to predatory pricing where a dominant entity prices below cost in order to drive out efficient competitors from the market. In general, discounts are less likely to be problematic if they are based on objective criteria that apply equally to all customers or if the discounts can be objectively justified. In contrast, individualized rebate schemes that are customized to require the customer to buy all or more of his supplies from the supplier is more likely to be problematic, as this will have the effect of an exclusivity restriction. Discount schemes are also more likely to be anti-competitive if the discounts apply backwards from the first unit of purchase once the customer crosses the target. This is because it provides much more incentives for the customer to buy everything from the supplier to reach the target and enjoy substantial discounts. In Singapore, the competition regulator has in past cases taken issue with loyalty-inducing and conditional rebates that have an exclusivity effect. When assessing discount schemes, the competition regulator would generally look at the effect or the likely effect of the discount scheme on competition. In this regard, the regulator will consider how the discounts are structured, including the duration and the quantum of the discounting, as well as the market circumstances such as the market shares of the parties involved, as well as the share of the market that is covered by such practice. Competition regulators will also look at whether or not there are objective justifications for the discount scheme. In summary, while discounts can be good for competition and consumers, they can also be used to unfairly drive out competition. Therefore, companies must be careful about how they design and implement their discount schemes. I'll now turn it over to Supawat to share more about the provision against unfair practices in Thailand.
Thank you, Tanya. Discounts or rebate schemes are also an issue for distribution agreements under trade competition law in Thailand as well. However, our approach differs from Singapore's approach because vertical agreements are regulated in Thailand regardless of the dominant position of the parties. So, this is similar to what James has discussed earlier for vertical agreements in Malaysia. What is unique about the Thai Trade Competition Act is we have one particular provision on unfair trade practices, or Section 57, which serves as a catch-all provision. The provision broadly prohibits practices which are not free and fair and cause damage to other business operators. Infringement can result in a fine up to 10% of the revenue in the years of the offense. When we mention about unfair trade practices under Section 57, we are talking about three issues. First, unfairly obstructing the business of other operators. Second, unfairly utilizing superior market power or bargaining power. The superior market power or bargaining power will happen when your distributor relies on 30% or more of their revenue from the purchase of goods from you. And last is fixing trade conditions which unfairly restrict or prevent the business of others. Because the prohibitions under Section 57 are very broad and case-specific, the Trade Competition Commission has issued guidelines to help businesses be aware of the red flags in respect of their actions. We have seen notifications on Wholesale Retail Business Guidelines, Franchising Business Guideline, Food Purchasing Business Guideline, and the latest one is Online Food Delivery Guideline in November 2020. The Online Food Delivery Guideline mentions examples of discriminatory income sharing charges between restaurants, which we normally call GP and other unfair conditions. For instance, the delivery platform cannot require exclusive dealing or forbid restaurants from making sales via other online food delivery platforms unfairly. At this point, you may think that these terms on income sharing or attempts to have a certain level of exclusivity are quite commonly found in distribution agreements. So, how to deal with it? The key is whether your terms and conditions are set unfairly or without justifiable reason or not. If not, your transaction is still okay. We always advise our clients to think about the commercial or economic reasons to support their actions. In the recent Commission's ruling in February 2021, it rules that the online food delivery platforms did not violate Section 57 because the different service fee rates charged to different restaurants are based on the cost-expense structure, and the conditions were put in writing and fairly negotiated based on market circumstances. The last point that I would like to make here is the notification on online food delivery guideline indicates the regulators' activeness in responding to competition issues and concerns in specific business sectors. So, I believe the regulator will issue more business-specific regulations in a near future. Hence, we have to keep an eye on this issue closely. Back to you, Carla.
Thanks very much, Tanya, Supawat. Again, the issues that you raise are different, are complex. But of course, we as lawyers can always simplify it, right? And ladies and gentlemen, you have now heard about some of the critical elements of drafting distribution agreements. Noting that distribution agreements do cross multiple jurisdictions, it is critical to bear in mind that whilst the general principles are similar, the laws do differ from country to country. Hence, how you structure the agreement and the specific clauses that you use are going to be important. It does require some planning ahead. And what we would always recommend is, please do revisit your distribution agreements regularly, review them, think about whether clauses need to be amended. And one reason for that is because competition law has now been introduced across most of the ASEAN countries. Your existing agreements may not have taken that into account. Second reason is because your distribution structures could have been tweaked and you're going to be crossing different jurisdictions. And hence you want to ensure that you're covering yourself regardless of which jurisdictions you go into. We hope, having listened to us for the last 20 minutes or so, that you have found the session useful. Please do feel free to drop us any comments or feedback you might have, and of course, questions as well, through the usual means that you know how to contact us. You can use the RTA website or reach out to us by email, our direct lines, our mobile numbers, and so forth. With that, it remains for me to say thank you very much and have a great day ahead. Thanks, everyone.